I'll now ask my learned sister, Lady Justice Ongudi, to deal with the next issue.
So the next issue is on the financial implications of the creation of this office and whether the same is a waste of public funds contrary to Article 10 of the Constitution. We have already considered the submissions of the first and fourth petitioners on this issue as set out above, as well as the responses by the second and fourth respondents and the first interested party. We take note of the first petitioner's argument that the advice given by the fourth respondent to the fifth respondent in respect of the remuneration and benefits for persons appointed to the office of CAS was inaccurate and misleading. This was due to lack of information as to how many positions would be created. On the other hand, the fourth petitioner argued that the appointment of CAS is a waste of public funds and resources in the face of the high unemployment levels and economic recession facing Kenyans, that the payment of such salaries ran counter to the provisions of Article 10 of the Constitution with specific regard to public funds, resources, good governance, transparency, accountability, and sustainable development. The first petitioner argued that the fourth respondent did not give advice on the financial implications in creating the office with a complement of 50. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230(4)(a). Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022. The second respondent submitted that the legislature has the power over public finance and the independent offices of the control of budget and the Auditor General to report to it. These are the offices that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CS was issued within their constitutional mandate under Article 230, Subarticle 4(b) of the Constitution and Section 11 of the SRC Act and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4 and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CSS or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. We referred to Article 230, Subarticle 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Rima J in the Okia case found that failure to involve the fourth respondent on the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honored brother, Justice Alem Fisram.